Good morning, everybody. Welcome to Fortis Friday series, Let's Talk. Today's topic is property-related disputes and how they can be prevented. In this webinar, our speaker, Mr. Patrick Tan, will share what the 5 common property-related disputes are and how they can be prevented. For a start, I'll just share with you a little bit about our law firm. Fortis Law Corporation is an award-winning law firm that started in 2003. Our client-centered legal solutions are focused on meeting the needs of private clients, spanning from estate planning, asset protection and preservation, real estate and family matters, as well as our corporate client practice, which looks at litigation and dispute resolution, and of course, corporate work. Presenting at today's webinar is the founder and CEO of Fortis Law Corporation, Mr. Patrick Tan. Patrick's areas of practice include commercial litigation and arbitration, wealth management, private client matters. He is a notary public, commissioner for oaths, a fellow of the Singapore Institute of Arbitrators, as well as an accredited associate mediator appointed by the Singapore Mediation Centre and the Primary Dispute Resolution Centre of the State Courts of Singapore. So right now, I'll just hand this over to Patrick to really enlighten us and inform us of the disputes, the common property-related disputes that we are faced with today. Thank you. Over to you, Patrick.
Thank you, Jacqueline. Hi, good morning, everyone. Can you hear me loud and clear? And I'm going to share screen. If you can hear me and see my screen, can you type 1 in the group chat so that I know? Just type 1 in the group chat. Okay, thank you, everyone. Yes, I see many ones. All right, thank you very much for joining me this webinar. So today I'm going to share something for the first time. It's a new topic that I've not previously covered. This topic is called property-related disputes and how they can be prevented. All right, a new topic, a new webinar topic that I've not previously covered. So I'm going to take the next 30 minutes to give you a broad overview of what these property-related disputes are and how they can be prevented. So in my law firm, we do property-related disputes quite often. And so I have summarized some of these common property-related disputes in this webinar, right? And how these disputes can be prevented. If you have any questions related to what I share this morning, please feel free to type it into the group chat or on Facebook Live, right? It is also on Facebook Live. And I also have my colleague Berlin with me, right? So Berlin will also help me answer some of your questions. All right, without further ado, let me go straight into the webinar. So there are 5 common property-related disputes as far as I am concerned. This is, of course, speaking from my experience, having done this for many years. First dispute, is disputes related to inherited properties. So, of course, when properties are being passed down from one generation to another generation, of one person to another person, right? Sometimes disputes may happen, especially when estate planning is not done properly. All right. We also see disputes relating to the title of the property, right? For a variety of reasons, sometimes the title of the property may not be in order. So that may actually create disputes also between the parties, specifically the buyer and the seller, or a third party. And the third type of common property-related disputes relates to delay in transferring the property, right? Again, due to a variety of reasons. For example, the lack of funds, that may actually cause a delay in the transference of the title. And also joint venture, sometimes we find that, parties enter into a joint venture in investing in properties, and then later something happened and the joint venture did not turn out as planned, and that may actually result in disputes. And of course, lastly, tenancy disputes, which unfortunately is becoming fairly common nowadays. So broadly speaking, these are the 5 common property-related disputes in Singapore. As I mentioned earlier, I will also share how these disputes can be avoided. All right.
Sorry, Patrick, you haven't shared your slides yet, right?
Huh?
Yeah,
Oh, everyone share my slides?
Yeah. Thank you. Thank you.
All right, sorry. I keep on talking without sharing my slides. All right, no loss. So can you see the slides now? Can? Jacqueline, can you see the slides?
Yes, yes.
All right, okay.
Thank you.
So just to recap, these are the 5 common property-related disputes, right? Disputes related to inherited properties, disputes relating to the title of the property, and delayed transfer of property, joint venture property disputes, and tenancy disputes. All right. So for the first part, disputes related to inherited properties. Such disputes typically occur as a property is passed to the next generation, from one party passed to the next. Typically from parents passed to the children, as certain family members may be dissatisfied with the share that they have inherited, right? Unfortunately, this is fairly common, especially when the deceased parent rather, did not actually plan properly, and this may result in actually disputes among family members. Okay, so how do we prevent, right? Of course, we always encourage property owner to do estate planning and to make a will, and to ensure that the will is updated on a regular basis as is in line with your intention and wishes and the legal requirements of Singapore, right? But disputes may still arise as a will can be contested in a court of law. To prevent one's will from being disregarded by the court, right, I would strongly encourage you to engage a lawyer or a professional will writing company to prepare your will, and also to choose your executors wisely. Now, executors are people appointed in your will to administer your estate upon your passing. So these executors can be your next of kin, can be your beneficiaries. So these are trusted people, right? And also to ensure that none of the beneficiaries are present during the making and signing of the will. These are some of the ways in which you can ensure that your will cannot be contested, or at least makes it very difficult to be contested. All right. So these are generally the ways in preventing disputes related to inherited properties. Maybe just to give you a context, right? I have come across, of course, disputes related to inherited properties. There are so many examples, so many real cases that I have come across. Now I am just trying to rack my brain to share with you some of these cases. All right, maybe this one, okay? It's a very sad case. So many years ago, this couple actually owned a HDB flat as tenants in common. All right, tenants in common, it means that the husband owns 50%. Tenants in common in equal share, rather. The husband owns 50% of the HDB flat, and the wife owns 100% of the 50% of the HDB flat. And the husband, actually, or maybe I should share this other story first. Sorry. So this guy, this late husband had a HDB flat, a 5-room flat. He stayed in this flat with his wife, all right? But his wife is not an owner. The wife is what we call a permitted occupier of the flat. So both of them have lived in this flat for 20, 30 years. Unfortunately, the husband passed away without a will. All right, the husband passed away without a will. And then what happened? Right? He passed away without a will under the Singapore law, right? If you pass away without a will, your estate, your assets, including your HDB flat, will be administered or distributed in accordance with the law. And this law is called the Intestate Succession Act. So under the law, right, because the husband died without a will, the wife get half, and their 3 children get the other half share of the HDB flat. So that was the easy part. But the problem is that the 3 children also own their own flats. So we all know that under existing rules, right, you cannot own 2 HDB flats, am I right? Flats. So what happened is that I told the children, so you have existing flats, so you cannot take over this flat of your father. So the flat would need to be sold. But you can always consider giving up your half share to your mother, right? Because your mother is still living in the flat. So you may want to consider actually giving your half share to your mom so that she can continue to stay in the flat. But guess what happened? The 3 children refused to give up their half share and proceeded to sell the HDB flat in the open market, right? Because they needed the money. And what happened to the poor mother? They actually put the poor mother in the old folks' home. all right, and she is still staying there, I believe. All right, so this is a real case. So it's very sad, and because the father did not plan, the father probably assumed that the three children will look after their mom. But well, his assumption was wrong, right? What he perhaps could have done is to make a will and say that when he dies, he would give the flat to his wife to ensure that the wife always has a roof over her head. And then for the wife to then make a separate will that when she dies, she gives the flat to her three children, or maybe even to give it to charity, to sell it and give it to charity, right? But because the late husband did not do a will, did not do proper estate planning, it resulted, you know, in this unfortunate situation, right? It is a real case. There are so many other cases, similar cases. I've done another one, and this is related to a divorce proceedings, right? This guy filed divorce. I did the divorce. He had a HDB flat in Bedok North, a 3-room flat. Unfortunately, before his divorce was finalized, he committed suicide. He committed suicide in his flat, right? So when your divorce is not finalized, and your marriage still subsists, right? So what happened was that, under the Intestate Succession Act, again, because he passed away without a will, his wife, whom he was in the midst of divorcing, get half of the HDB flat in Bedok North. Because they had no children, his parents get the other half. All right, was very unfortunate, right? These are all real cases that I have done, right? So my point is that if you have a property, you have to make sure that you actually do what is necessary to prevent disputes. Otherwise, it may not be you who suffer, it may be your loved ones. Right? Another example that I like to share. I know newlywed couples, right? A lot of newlywed couples, they buy new flats, BTO flats and all this. And many of them buy these new flats as joint tenants. That is the other form of co-ownership. Joint tenants as compared to tenants in common. Joint tenants means the husband and wife owns 100% of the flat. There is no demarcation of the share. And more importantly, the right of survivorship will apply. Meaning, what is the right of survivorship? Meaning, if the husband, for example, were to pass away first, the husband loses all the interest in the BTO flat. Or conversely, if the wife were to pass away first, the wife loses all the interest in the BTO flat. Whoever survives becomes the sole owner of the BTO flat. And the law also says that, this is the Civil Law Act, what if both of them were to pass away together? For example, while on a holiday, in a common accident, both of them were to pass away first. Now, the law presumes the older one by date of birth to have passed away first. All right. So if the husband is the older one by date of birth, he will be presumed to have passed away first. All right. Then what happened to the BTO flat? If you recall, under the right of survivorship, the wife will become the sole owner of the BTO flat. So for this newlywed couple, right, many of them do not have children yet, right? So in the unfortunate situation, if both of them were to pass away together, the law will presume that the husband had died first. And this BTO flat would belong to the younger wife. But of course, the younger wife had also passed away, right? Now, who would benefit? Now, who would this BTO flat go to? Under the Intestate Succession Act, because both husband and wife did not do a will, the BTO flat will end up in the hands of the wife's parents. You know how scary that is, right? In other words, the husband's family, the husband's side will not get anything as far as the flat is concerned. And if the wife's parents already have their own HDB flat, then this BTO would have to be sold or even surrendered to the HDB if the MOP period is not fulfilled, right? In other words, right, if both this newlywed couple did not do a will and both of them happen to pass away together, the law would presume the older one by date of birth to have passed away first. So this BTO flat or whatever that is left would not benefit the husband's side of the family. Right? This is how scary it is. Just to give you an example, why estate planning and making a will is so important to real estate. Because real estate is often a substantial part or substantial asset of many people, especially in Singapore. It is important for us to plan properly that when our time comes, how or who would this property go to, right? And why do we need estate planning? So that we can prevent disputes. right? Related to these inherited properties. Otherwise, disputes may happen. The family members may hire a lawyer, go to court, fight it out. At the end, whatever hard-earned money that you have may end up as legal fees. What about disputes relating to the title of the property? Right, the second type of dispute. Title of property disputes are normally traced back to the time when the property was purchased. Right? For example, third-party claims, co-ownership claims, and the right to access a property can also lead to the title of property dispute. So when a property is owned by co-owners, for example, right, a dispute may arise when the property is sold and one of the co-owners actually wanted to achieve an amount more than what he or she is entitled to. Additionally, a failure by a party to honor their part of a contract after receiving an advance payment may also lead to a dispute. Now, to share with you another real case. So this HDB flat was co-owned by mother and daughter. All right, mother and daughter own the HDB flat as what you call that? Joint tenants, right? Joint tenants. So why they co-own the flat was because the mother wanted to buy the flat, but for some reason, because of her age probably, she could not take a bank loan. So the daughter had to come in as a joint owner in order to secure financing. So that was the background to the story. And then because unhappiness arose between the two and they wanted to part ways. So the daughters told the mother that, okay, since now we cannot live together, let's sell the HDB flat. So the mother said, well, I don't want the flat to be sold because I am still living here. And if you want to sell it, right, then you have to basically give me 80% of the HDB. All right. Of course, the daughter refused. The daughter said, well, I took up financing. I paid most of the installment. I should get 80%, mom, not you. So what happened? Went to court. Right. I can't remember what was the outcome, but I remember there was this case, another similar case. This one between mother and son. So basically, same thing. Mother and son own the HDB flat jointly. And what happened was that, when the son goes to work, the mother would help look after the grandson, right? So, but what happens is that the grandmother would always beat up the grandson, So that created a lot of unhappiness in the family, to the point that the son said that, Mom, enough is enough. I don't think we can live together. We want to move out. You can stay here alone and whatever. We don't want to stay together with you. So can we sell the flat? Because I also need the money to buy my own flat and stay together with my family, right? So the mother said, okay, if you want to sell, I want 100% of the sale proceeds. Can you believe that? So of course our client couldn't agree. So what happened? We sued the mother. So this is a tragic story of son suing the mother in court. And thankfully, we won the case. We got, I think, 75%, if I remember correctly, for this case, 75% of the sale proceeds. But it was very tragic because, you have a son suing the mother. We tried all ways to settle the matter, but the mother insisted on having a large share, even though she paid very little towards the purchase price. We couldn't reach a settlement, so the case had to go all the way to court. And we got 75%. So the flat was ordered to be sold in the open market, and our client got 75%. So again, these are real cases that I have personally handled that shows that there can be disputes relating to the title. So when you buy property as co-owners, right, you have to be very clear about the implications. Because co-ownership, there are a few types. Right, joint tenancy, tenancy in common in unequal share, so on and so forth. You need to appreciate the differences between the two at the point of buying the property, right? Because if you don't, later on there is a dispute, right? Then you will be facing with a huge problem, right? So it is important for you to appreciate the differences and go in with your eyes open, right? But how to prevent this dispute? We would, of course, strongly suggest that, all the co-owners enter into a contract, right, prior to the purchase, stating their respective shares in the sale proceeds in the event of. We do recognize that this is not common. Where got husband and wife go and enter contract when they buy BTO and they buy a flat, right? But at the very least, if there is no contract, please have that kind of understanding between each other, right? That, okay, why in what way do we want to own this property and why? Why do we want to buy it as joint tenants, 100% each, or why do we want to own it as tenants in common? For real estate investors, when they go into joint venture, they need to have a contract. But we recognize that for next of kin, family members, having a contract may not be the way forward. But this does not mean that there cannot be an understanding, right, or an agreement, right, between parties as to the respective shares, or as to how they want to conduct, right, themselves in relation to the title of the property in the event that there is a sale, or in the event that, let's say, they want to part ways because for whatever reason they cannot live together and all this. Another way to prevent disputes relating to the title of the property is also to carry out a proper investigation into the title of the property. All right. Again, I have another real case to highlight to you. This happened, I think, last year, early last year, in 2019. So what happened was that I got this new case where my client wanted to buy a penthouse unit, a penthouse condominium in Katong. So it was a steal. The property, the penthouse was valued at $5 million, but for some reason it was sold to my client at $3.5 million. So it was a steal, a fire sale, right? What they called it. So our client paid 1% and took the option. But later on, when it came to us, this matter, we discovered that actually the seller was a bankrupt. Under Singapore law, right, when a person is made a bankrupt, his affairs will be vested with the official assignee, or is vested with the official assignee, right? It is difficult for the seller to complete the conveyance process without the approval. In fact, it cannot be done unless approval of the official assignee is given. So can you imagine our client has paid 1%, right, and was about to exercise the option when we discovered that the seller was a bankrupt, right? So actually this created, of course, a lot of problems. But thankfully, when we wrote to the seller's lawyer, they confirmed that basically the bankrupt had the permission of the official assignee to sell it at $3.5 million, right? Initially, we were thinking that what if the seller did not have the permission of the official assignee? It would affect the conveyance, it would affect the transfer of the property, right? So careful investigation is important. That's why you need to have professionals who can actually help you do all these checks before you actually go and buy. But sometimes the title also, another example is that what if when you want to buy, it turns out that the seller has actually obtained this property previously as a gift from another person. This complicates matters, right? And this can be checked if investigation, what we call title search, has been done, right? We will be able to see whether this property, the seller property, right, was obtained previously as a gift. Because if it is a gift, then basically the buyer cannot buy with bank loans, because no bank will finance the purchase of a property that was obtained through a gift, right? So the entire sale and purchase may be jammed up, right? So you need to be very careful. You need to investigate into the title. And how you can do so is to do a search, right? You can do it with the real estate agent that you hire and all this. It doesn't cost a lot, right? You can do it between $5 to $15, and you can find out a lot of information related to the property. Okay. What about delayed transfer of property? Right? Disputes typically arise when a contractor delays the delivery of the property or the transfer of the possession of property. Right? Common causes of such delay would include land title dispute, right? Transfer of a project from one contractor to another, fallacious complaints against buyer, aim at getting buyers to pay a higher sum, right? So these are some of the common examples that we see, in this kind of dispute, right? For example, contractor, so when you hire a contractor to renovate or to do up your property, always ensure that the terms are clear in the contract. What are these terms? Basically, the scope of the renovation must be clear, right? Payment terms must be clear, right? Delivery must be clear, meaning time is of the essence. The timeline must be clearly stated. Liquidated damages, right? If there is a delay, What damages do you want? Must be clearly stated. Right? Payment mode, in what tranches, in various payment deposit amount must be clear. Completion deadline must be clear. Any variation order to the original contract must also be set out, right? Because we do recognize sometimes you may need to vary the renovation contract, so on. You want to add certain things to your renovation. Please make sure that they are not verbal. All these variations need to be in writing. So basically the terms need to be clear, right? And also if there is a dispute, right? How are these disputes going to be resolved? Is it to go to court, through mediation, through arbitration, right? Basically have a properly drafted contract. Your contractor may forward you a contract, a fairly simple contract, right? Please take some time, look through it, especially if it's a big contract, get your lawyer to look through it, right? To ensure that, because your renovation bill can be in the hundreds of thousands, if not millions of dollars, right? You want to have a good contract to protect you. Otherwise, it may result in delay, especially in times like this during COVID-19, right? When contractors cannot do work, previously during the CB period. So a lot of delays have happened. Now the thing is that now that it is phase 2, right? The contractor, some of them can actually start work or continue the work. Now the question is then what happens to the original timelines stated in the original contract? Do they still apply? Can they be extended? And if these timelines are extended, what are the terms of this extension? Again, all these, please iron it out, have it in black and white. Okay, because I know that there are projects who were being stopped during the CB period, and now works have restarted, right? It is important to revisit the terms in this contract and make sure that everybody's interests are protected. So enter into a contract with a BCA license. This goes without saying, right? Or certified builder or developer that will give you extra protection, who has clearly outlined and approved plans in place. Always make sure that your plans are approved, right? I mean, especially for houses, right? If you want to do all this A&A or reconstruction, all this, make sure that you have a plans that are approved, that is approved by BCA before you start work. Okay, all right. And also, please check the terms of the contract, as I mentioned earlier, before signing it, right? And ensure no hidden costs, and if possible, to include the LD clause for delay. If there is variation, please have it contract also in writing. Thoroughly investigate the title of the land and the property before purchasing it. Especially, when you are buying a house, make sure there's no unauthorized A&A that you may want to verify. Do a physical visual inspection, look at the plans. You can actually extract the plans from BCA, have a look, or if it's a big project, you may even want to hire an engineer or surveyor to have a look and make sure there's no unauthorized A&A before you actually commit to buy that property, right? Investigate also the contractors, developers, to see if they have the ability to complete projects, right? In carrying out this investigation, you're also advised to find out whether there's any pending litigation. That again, you can do checks. You can go through your lawyers to run some checks on your contractors, developers, to see if there are any pending litigation cases against them. And the number of projects that have been successfully completed. So you want to see whether they are legit or not, you see, right? And these are all fairly commonsensical checks that you can do, right, before you actually commit to buy these properties, because you really do not want to have any delay in the transfer of property, in the conveyance of the property. And of course, monitoring the construction progress of the work by regular inspection and having a copy of the timetable from the constructor, the contractor, right? In a larger project, you may have the project manager helping you. But for smaller projects, all this, you will have to actually be more hands-on and actually go to site more often and monitor the progress of the work. Now, joint venture property disputes. When a joint venture is terminated, so this happens when, let's say, a group of people come together and make joint investment in a property, right? When they do this, it is important to actually have a joint venture agreement clearly drafted to protect everybody's interests. Now, when a JV is terminated or when a partnership comes to an end, disputes may happen when determining the ownership of a property or property that were acquired by the joint venture company, right? So a group of investors may come in individually and collectively and invest in a property, or they may decide to set up a JVC, a JV co, a company, and invest into this property. regardless the case, it is always important to have a JV agreement governing the relationship between the parties, because these are substantial investments. You're going to come together and invest in a real estate, right? So please have a JV agreement in place. And in this agreement, you need to set out terms like, okay, who's going to pay for how much, and basically what is the objective of this joint venture, if it's going to be sold eventually, what is the timeline, right? And then who is going to pay for the cost, and how are the sale proceeds divided after the sale. All these need to be clearly stated in the JV agreement. All right. Tenancy disputes, right? This unfortunately is becoming very common nowadays, right? Example of tenancy disputes will include disputes relating to rent reviews, commercial lease renewals, and whether a landlord is entitled to repossess a property. During this pandemic time, we are seeing an increase in such cases, and that is also the reason why our government has introduced the COVID-19 Act, right? And under this act, if you recall, right, leases and tenancy agreement is specified contract. In other words, this kind of contracts, they are offered protection under the law, right? So if tenants in commercial properties or industrial properties find that they are in a position of not being able to pay rent, they can always seek protection by filing this document called a notification for relief on their landlord. And if relief is granted, basically they get a deferment of rental during the prescribed period. The prescribed period will end sometime in October. So in other words, during this period of time, the tenant does not need to pay rental. So this period of time, all the rentals are deferred till November. And the tenant can also apply for an installment scheme to pay this deferred rental starting from 1st November. So if the tenant requires to pay all this deferred rental through installment, they can apply for such a scheme. The installment plan is 9 months, or for the balance of the remaining tenancy period. Okay, so these are all protections that are out there to give to the tenant. So please share, if you find that tenants were unable to pay, right, they can always apply for this relief. And what are the other common causes of tenancy disputes? Well, we have landlords unreasonably increase the rent of the property, tenants failing or refusing to pay their rent. This is common, unfortunately, right? Or damages caused to the property, or breaches of TA by either party, right? So these are all common reasons for tenancy disputes. In fact, in my experience, the most common one is the refusal to pay rent, or basically lateness in paying their rent. And for this to happen, and if this happens, this is a very serious breach of the TA, what we call a repudiatory breach. And the landlord actually can invoke their right under the TA, tenancy agreement, serve notice and demand payment of the rent and interest. And if that is not forthcoming, right, the landlord may even actually repossess the property. All right, exercise the right of re-entry and repossess the property, so on and so forth. So these are very serious breaches, right? So I always advise the tenant, please do not withhold the rent, right? If you need to, because of COVID-19, because of the pandemic situation, please put in the notification for relief on your landlord. At least you are given protection under the law. All right, do not suffer in silence. So broadly speaking, these are the 5 types of property-related disputes. Of course, they are not meant to go into details in depth because we only have half an hour worth, right? So how to prevent TA disputes? So expectations from both parties, landlord and tenants, need to be clearly stated in the TA. So do not just flick through the TA without understanding the terms, right? Make sure that both parties are on the same footing as far as the TA is concerned, right? The terms are all agreed, right? And also rent records and any other financial documents related to the rent should be kept separately from other records. Basically what we call paper trail, keep it properly, right? All your IOU, not IOU, sorry, your letter of intent and your TA, your letter of offer, all this, please keep it properly. All right. Okay, I have come to the end of my sharing, so the time is about right. So these are the practice areas that my law firm provides. I'm heading the private client practice group. My other director is heading the corporate client. So under private client practice group, real estate is one area that my team actually does very often. and contact details of my team members. So in my team, I have Berlin, who is in this webinar with me. I have Andrew and Jacqueline, my business development manager. All right, you can contact any one of us. And we have 2 offices. Our HQ is at Raffles Place. We have another office at Jurong, CPF building. And I would also like to invite you to like us on Facebook and LinkedIn, because we organize such webinars from time to time, and they are all free. You are welcome to actually join us in this webinar. So please like us on Facebook and LinkedIn. So thank you very much. I've come to the end of the sharing. If you have any questions, please feel free to type it into the group chat, and I will try to answer these questions. Berlin, are you there?
Yeah. Sorry, Patrick, there are some questions already typed into the chat group.
Yeah, let me take a look. Okay. An only child inherited a private property from the parents. Sorry, what's the question? Okay, on the.
I think his question continues. This is from Bill. I think his question continues later. The whole question comes in a bit later. You can just scroll down the chat. Yeah.
Singaporean married with a PRC wife more than 10 years ago. Second year after marriage, the wife took the original marriage cert and left him. Never had any contact. The husband had made police report. What can the husband do now? I mean, this is related to, of course, marital proceedings, right? I think first the husband has to consider his marriage first, right? Okay, the husband had make a police report. What can the husband do? I think the husband, okay, what is the cost to file a divorce? Do your law firm provide? Yes, unfortunately, we do a lot of divorce cases, right? So please contact myself, Berlin, or Andrew. We will be able to give you a fee code for divorce cases. In this case, can the husband still sell the flat? The wife registered as occupier. Yes, as an occupier is not owner. The husband can actually sell the flat. If the husband is the sole owner of the flat, he can proceed to sell, notwithstanding the matrimonial, the divorce proceeding, right? There is no requirement that he has to divorce before he can sell. He can actually sell now even without filing any divorce. All right. Okay. Now I see Bill's question. Okay. Only child inherited a private property from the parents. The child owns a HDB but yet to fulfill M. Can the execution of the grant or the transfer be delayed? Okay. First thing first. If you have a HDB, the child is a HDB, but he's going to inherit a private property. The question is yes and no, because I mean, if the HDB knows about it, they would actually want the property to be transferred ASAP, all right, and not be delayed until the child's MOP period. Any court approval needed for the delay of this transfer? Of course, if the transfer is not done within the prescribed period, right, you will need an application to the court to explain why the delay, and also to want the court to actually grant you the extension for the transfer. Transference of property pursuant to inheritance, there is no stamp duty payable. All right, no ABSD, no BSD. Okay. For rent deferment, no, rent deferment, basically we're talking about the COVID-19 measures, right? It only applies to non-residential properties. Non-residential. All right. How does the tenant apply for deferment? Okay, basically can go to Ministry of Law website. There is a link there, a notification for relief. Ministry of Law website. All right, the tenant can go to this website and click on the link, notification for relief. In one earlier webinar, you advised even after landlord re-enter lease, tenant can pay out a rent. No, yes, and have a right. That is under Section 18A of our Conveyancing Law of Property Act. That is what we call relief against forfeiture, Michelle. Then that is too bad for the landlord. The landlord has to settle the new tenancy. So the landlord has to be very careful. Until the issue with the tenant is resolved, I would strongly advise the landlord to be cautious and not commit to a new tenancy. You are right, Michelle. I mean, what happened if the court order the landlord to basically return the premises to the tenant? Then the landlord will be stuck, right? Oh, Okay, any other questions?
Yeah, I think there's one. Lynette has raised her hand. Lynette, do you want to ask the question? Unmute yourself and ask the question. Lynette raised her hand earlier. No?
Oh, okay, let me look at Facebook Live. No questions. Wow. For once today, there isn't too many questions. Oh, okay, there's a question. Shouldn't jinx myself, I think. No question. Please clarify if seller obtains property by gift, the buyer cannot buy. Yes, that is correct. What if it is established that the title is clean? It is not clean, ma. If the property is obtained by gift, in law we call it unclean title. Right, so it is not clean. If the seller has obtained the property by gift, the property is not clean. And no bank will finance the purchase. So in other words, the buyer has to buy with full cash, full cash. So that's why it is important to do a check, a search on the property. And the result, at the bottom of the search report, you can see whether the seller, how he had acquired this property previously. Is it by gift or by sale, or so on and so forth. For a non-resident tenant, landlord already relieved 4 months rental, but tenant still negotiate. Can landlord reject? Yeah, why not? Can reject. Okay, but I guess we can always help parties to come to a settlement and negotiate, right? Because this is a very difficult time for everyone also. Any other questions? Yes, this webinar is recorded on my law firm's Facebook page. If you missed whatever I have shared, please feel free to view the video after this webinar. All right. Along with our other Facebook, our other webinars, some of them are recorded. So they are posted on our page. Please go there and view it. And we have also written some articles actually. So if you go to my law firm, right, under the publication column, over the years, we have written quite a number of articles. Feel free to actually download this article, have a read. In fact, on today's topic, right, we have also written an article. We have also written an article on today's topic. So in case you have missed out whatever I have shared, please download this article. Or maybe Yue Ling, do you have a link to this article? Oh yeah, very efficient. So you can see the link to this article is here. Feel free to click and download this article and have a good read. All right. Any other questions?
Yeah, any more questions? Last call for questions.
Last call.
All right. Okay.
If there's no further questions, thank you very much, everyone. Stay safe and healthy. Have a good weekend ahead.
All right. Thank you, everybody. Have a good Friday and a good weekend. Bye-bye.
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 Bye-bye.